2, 1.
Okay guys, welcome once again to another episode of Scott Talks Law. So this is an episode whereby Scott Talks Law. And in this episode, we shall be talking about the modes of land acquisition. So there are 4 modes of land acquisition. We have possession, prescription, agreement, and inheritance. So the first mode of possession, this is the objective realization of ownership. And this is the mode that involves physical control over a thing or property. And according to this mode of possession, property or anything that belongs to no one or no one can claim legal title over it belongs to that person who first comes across it. So it's based on the principle of res nullius. And according to this principle, that if property exists without one claiming title over it, then the first person who comes across it has that title over that piece of property over the whole world. Still under possession, we have adverse possession. And adverse possession, this is the mode that exists where there is continuous use of land for like 12 years without interruption. If there is an interrupted use of land for continuously for 12 years, then that person who uses that land has legal title, obtains legal title over it. So there are 2 types of adverse possession. We have relative and absolute adverse possession. So absolute adverse possession is the perfect mode of adverse possession, and relative adverse possession is the imperfect mode of adverse possession. So the second mode of land acquisition is prescription. And prescription, this is the mode that involves the creation or destruction of rights to a particular piece of property by the elapse of time. So this is the mode that involves the creation or destruction of rights to land by the elapse of time. So there are 2 types of prescription. You have positive and negative prescription. So positive prescription is also known as the acquisitive prescription, and negative prescription is the extractive prescription. So under positive prescription, an example is adverse possession. And this is the process that involves the creation of rights through the elapse of time. So the time period there is 12 years. So if someone has been using that piece of land for 12 years, then the rights are created through the elapse of that 12-year period. So adverse possession, this is the interrupted use of land for a period of 12 years. Then someone will obtain rights over that piece of land. So that is according to the positive acquisitive or acquisitive prescription. And other examples are like easements and waivers. So there are 3 examples of positive prescription: waivers and easement and the adverse possession. The second category of prescription is the negative or extractive prescription, and this is the destruction of right through the elapse of time. So the right to government to reclaim a lease upon the expiry of time is an example of a scenario where this negative or extractive prescription exists. So the third mode of acquisition is acquisition by agreement. So and property may be acquired by agreement where the owner exercises their legal right to dispose to another without or with consideration. So the owner confers this property to another person with or without consideration. So if it's through consideration, then that is referred to as price. But when it exists without consideration, it's referred to as a gift. So it's one of the important principles of law based on the principle of nemo dat quod habet legem. And according to this principle, no one can convey better title than he himself has, as a general rule. So nobody else can confer a title to a right to property unless it's that person who owns that piece of property. That's according to the principle of nemo dat quod habet legem. So section 3 of the law of contract Act Cap 23 provides for an exemption to the law of contract. So agreements relating to land must be in writing. That's according to Section 3 of the Law of Contract Cap 23 of the laws of Kenya. It demands that agreements relating to land must be in writing. And that's against the law of contract that demands that a contract can be oral or implied. So agreements relating to land must be in writing. And this agreement relating to the land, there must be a witness who witnesses the signing of that contract between those parties. There must be a witness who witnesses the signing of that agreement. And it must be signed by all parties. The agreements relating to land, it must be in writing, it must be signed by all parties, and it must be witnessed by a person who witnesses this party signing that agreement. So the fourth mode of property acquisition is acquisition by inheritance. And this is the mode that property is acquired after the death of the owner. So the deceased dies and leaves this property to other people. So the deceased or someone who dies can die with the rights or can also die without. We can leave behind the rights. So there are those rights that this person can die with, and there are those that someone cannot die with them. So proprietary rights are those rights that proprietary rights are inherited. One does not die with them, while personal rights are those rights that die with the person. They cannot be inherited, they are non-inheritable. So you have exemption to these proprietary and personal rights. Like proprietary rights cannot be inherited where there exists a list. Where there exists a list, these proprietary rights cannot be inherited, and personal rights can be inherited where there exists an hereditary agreement. So where a person dies, this person can also leave a will saying how the property is to be distributed. So the property here will be distributed according to the terms of the will. And if this person dies without leaving a will, then the state shall take that property and so it's further submitted that beyond these four methods of land acquisition, land can also be acquired through auction and transmission. So land can also be acquired through auction and transmission. So that is the end of my lecture, and stay tuned for more episodes.